Hello everyone, this is ILC Bala. We are trying to decode various labor laws of our country. We are also discussing various court judgments, Honorable High Courts and Supreme Court, important judgments specifically related to labor laws, especially Employees Provident Fund and Employee State Insurance. Today we are going to discuss an important judgment by the Apex Court, that's Honorable Supreme Court of India, where it dwelt upon the applicability of the Act to an establishment, because that establishment challenged, this Act is not applicable to them. So before we discuss the Honorable Supreme Court judgment, let's first understand applicability of the EPF Act, to whom it's applicable. What does the provisions say? So according to EPF Act, Section 1, subsection 3, the conditions are as follows. Subject to the provisions contained in Section 16, it applies, means other than Section 16, what is specified, that is with respect to the exempted establishment, very specifically, that's a different scenario. Other than that, it applies to number 1A, every establishment which is a factory engaged in any industry specified in Schedule 1, where 20 or more persons are employed. B, that's the second one. Any other establishment employing 20 or more persons. Within that class of such establishment, which the central government may, by a notification in the official gazette, specify in this behalf that this act will be applicable. So this means there are three things in this. This act applies to a factory which is in a specified industry as given in Schedule 1. So if it is given in Schedule 1, that industry is being operated by a factory, then it applies. That is, of course, the common parameter is 20 or more persons. Second, any other establishment employing 20 or more persons. Third, the government, the central government may, by a notification in the official gazette, declare a particular industry or an establishment to be covered under the Act. So these are the three conditions. So before the central government takes a call to include a particular industry, the provision is that a 2 months notice period, all those things are available in the Act. Right. Now let's discuss this important judgment in this Supreme Court. It was in the year 2023, November. Okay. So let's discuss this. The background of this case is that the appellant was involved in manufacturing, assembling and selling of umbrellas. The respondent being the Regional Provident Fund Commissioner. So what happened? The Regional Provident Fund Commissioner, upon inspection, issued a notice to this particular organization stating that EPF Act is applicable to them. So it was stated very well in the notice, how is it applicable? Because it's a factory. Is it coming under that industry under Schedule 1 or not? We have to specify. Or whether it is an establishment covered under the Act under different provision or not, we have to specify. So what did the Regional Provident Fund Commissioner do is that after inspection, you should have noticed that your establishment is covered and it falls under the category of trading and commercial establishment as notified by dated number 7th March 1962, issued by the central government in exercise of its power conferred under clause B of subsection 3 of section 1. So what did the government do? The central government used this clause wherein a provision is given under the Act powers to the central government to issue a notification that a specific establishments will be covered under the Act. If it is not covered under this specific industries under Schedule 1 or not covered as under a general establishment, it can be covered through a notification issued by the central government. So taking this cue, the Provident Fund Commissioner upon inspection issued a notice to this organization. The organization, the establishment, filed a review petition and the same was rejected by the respondent commissioner, because generally you make a review petition with the commissioner of appeals, right, before you move forward to seek further remedies. So that was rejected. Then the establishment preferred an appeal in the appellate authority, which was also again dismissed. Agreed by the order of the establishment filed a writ petition in the High Court. That's the procedure, no? So in the High Court, the single judge dismissed the petition and being confirmed by the Honorable Bench of the Kerala High Court also. Subsequently, the Kerala High Court also confirmed. So what happened? What is the remedy available to the establishment? They have to make an appeal to the highest court of this country, the apex court, being the Honorable Supreme Court. So now this is the appeal that is being preferred. That is why this current appeal is in the apex court, is against the order of the Kerala bench. So what was the submission by the counsel for the appellant? He submitted that the appellant is a factory. They are saying they are a factory not covered under Schedule 1 of Clause A of Subclause 3 of Section 1. So we are a factory but not covered as per Schedule 1, because this industry is not mentioned there. And further states that Clause B of subsection 3 of Section 1 does not include factory, because Clause B talks about establishment and the third sub provision. So he says that neither in the Clause A or Clause B of subsection 3 of Section 1 is applicable to them. Hence, they don't fall under the EPF Act. He also went further, submitted that under no stretch of imagination, appellant establishment can be called as a trading and commercial establishment. So you can't define them as a trading and commercial establishment also. Covered under the notification, because the government, the central government has the power, issued in the notification in 1962. So we are not covered under that also. That was the argument presented by the counsel for the appellant. That is the company. The counsel appearing for the respondent, who is the respondent here? The Provident Fund Commissioner. So submitted that the appellant is not only assembling or manufacturing, it is also involved in selling. Means they are assembling, manufacturing and selling also, which is clearly falling within the definition of trading and commercial establishment, because you sell, you manufacture and you sell. So you come under trading and commercial establishment. So it is covered under that particular notification. Hence, therefore, they contended that this act is applicable to them. After hearing both the parties, the court opinion, I am just quoting the court's opinion. Before we deal with the contention raised by the appellant, we must note here that the constitution bench of this court, in the case of Muhammad Ali and others versus Union of India. So the court is discussing about a particular important constitution bench judgment, which dealt with this particular interpretation of the provisions of 1952 Act, that is the Provident Fund Act, particularly with respect to subsection 3 of Section 1. The same section, the first section of the EPF Act and subsection 3, which talks about the applicability, was dealt by the constitution bench. The bench that time held that 1952 Act was made to institute Provident Fund for the benefit of the employees in factories and other establishments. The aim of that particular act was for what? Is to provide Provident Fund benefits to the employees in factories and other establishments. So that is why the provision of 1952 Act constitute a social justice measure. This act is a social justice measure. Then it went on to further say, the underlying idea behind the provision of this 1952 Act is to bring all kinds of employees. That is, the aim and object of this act is, over a period of time, it wanted to cover every employee within its fold, and if it has not been covered earlier, the central government is given the power through the act to cover any establishment by a notification through an official gazette and bring them under the purview of EPF Act, so that the employees are enjoying the benefit. So after considering clause A of subsection 3 of section 1, the Constitution Bench held that insofar as an establishment which do not come within the description of the factory engaged in industries enumerated in Schedule 1 are concerned, the central government has been vested with the power under subclause B of subsection 3 of section 1, and the establishment can be covered by the act. Subclause B of subsection 3 takes within its fold all establishments which are not covered by clause A. Therefore, a notification under clause B can be issued in respect of factories engaged in any industry which is not specified in Schedule 1. Hence, the argument that a notification cannot be issued under clause B of subsection 3 regarding a factory engaged in an industry not covered by Schedule 1 cannot be accepted, the court said. It went on further to say, under the notification dated 7th March 1952, because this is the notification that both the appellant and the respondent were disputing. There is a category of trading and commercial establishment which has been clearly mentioned. So admittedly, the appellant is carrying on a business of assembling or manufacturing and selling the items. The respondent has recorded a finding of the fact that the business of establishment of the appellant was an assembling umbrella and selling. The same is in her own outlet. Thus, the establishment of the appellant is a commercial establishment, the court decided. Therefore, it finds absolutely no error in the view taken by the single judge and the division bench of the Kerala High Court, and accordingly dismissed the petition filed by the company without cost. So the essence of this judgment is, the apex court rules government has the power under EPF Act clause B subclause 3 of section 1 of the EPF Act 1956 to declare any establishment not covered under clause A subclause 3 of section 1 to be covered under EPF Act. So the government has the power to bring any establishment within the purview of this Employees Provident Fund Act, and it can make it applicable to them. Hope it's clear to all of you. We will see you in another video. Thank you.